You may be able to beat a charge of negligent driving occasioning grievous bodily harm if there is insufficient evidence. Now, police must prove beyond reasonable doubt that you were driving in a manner that was less than to be expected of a reasonable driver at the time for you to be found guilty. This often requires proof that you were at fault in an accident or that you were otherwise doing something wrong, such as you were on the phone at the time, not using your indicators when you should have been, not keeping a proper lookout for vehicles or people around you. If there is not enough evidence to prove that you are negligent, i.e. at fault or doing something wrong, then your lawyer can write to the police and request that the case get dropped, and if they refuse to do so, they can fight to have the case thrown out. The second way you can beat the charge is if the injury did not amount to grievous bodily harm. So if your lawyer believes that the injury wasn't as serious as is required to constitute GBH, they can write and try to have the case dropped from negligent driving occasioning grievous bodily harm down to negligent driving not occasioning grievous bodily harm, which is far less serious. If police refuse to do so, and the case goes all the way to a defendant hearing, then the court can find you guilty of the lower charge of negligent driving instead. Now, thirdly, there are a number of specific defences to the charge. The first is duress, and that's where you're coerced or forced into driving negligently. Second is necessity. That's where you drove to avoid serious injury or death, for example, an emergency situation where you're driving someone to a hospital. The third is what's called honest and reasonable mistake of fact. And this is where you honestly believe that you are obeying the road rules and driving in the right way or at the speed limit, and that belief was reasonable in all of the circumstances.